Start. While dealing with issue number 5, the trial court concluded that since the stranger purchasers had purchased the 3/4 share from the other co-sharers after paying a valuable sale consideration, and the said sale deed was duly registered also, as the respondent herein had not given an unconditional offer to purchase the share of the earlier transferee, Shri Satya Prakash Nigam, hence could not claim the benefit of Section 4 of the Partition Act. Hence, the stranger purchasers were entitled to get their 3/4 share partitioned. Accordingly, decided the said issue in favor of the stranger purchasers, the appellant herein. In light of the aforesaid findings, the issue numbers 3, 4, and 5 were decided against the respondent herein. The trial court, by means of judgment and decree dated 21/2016, held the suit bearing number of 2007 to have abated, but declared the respondent herein the co-sharer having 1/4 share in the property bearing 19 50/8 and 50/110 situate at Jainarayan Road, Husainganj, Lucknow. The suit of the stranger purchasers bearing number 436 of 2009 was decreed, declaring them to be owner of 3/4 share in the said property and entitled to get their share partitioned. The counterclaim filed by Devi Shankar Shukla, the respondent herein, was dismissed. The respondent herein, being aggrieved against the said judgment and decree dated 21/2016 passed by the trial court, preferred to regular civil appeals under Section 96 CPC. The regular civil appeal number 62 of 2017 emerged from regular suit number 4 of 2007, whereas regular civil appeal number 63 of 2016 arose from regular suit number 436 of 2009. The lower appellate court noticed that the respondent herein did not press the regular civil appeal number 62 of 2017 emerging out of regular suit number 4 of 2007 and dismissed the said appeal as not pressed. While dealing with regular civil appeal number 63 of 2016, the lower appellate court framed the following points for determination: whether the respondent herein, the appellant, before the lower appellate court, was ready and willing to purchase the 3/4 share of the stranger purchasers in furtherance of Section 4 of the Partition Act; whether the trial court, while passing the impugned judgment and decree dated 21/2016, has misconstrued the scope and ambit of Section 4 of the Partition Act 1983. Upon hearing the learned counsel for the parties, the lower appellate court allowed the appeal and held that the house in question was a family dwelling house, and in terms thereof the respondent herein was entitled to exercise his right under Section 4 of the Partition Act 1893 and was entitled to purchase the share of the stranger purchasers for a sum of rupees 9 lakh. It also recorded a finding that the date on which the respondent herein exercised his right of purchase was the material date on which the valuation was to be considered, and directed the stranger purchasers to receive a sum of rupees 9 lakhs from the respondent herein to execute a sale deed in his favor within a period of 3 months on expenses and stamp duty to be payable by the respondent herein. The stranger purchasers, the appellant herein, have assailed the said judgment and decree dated 14/2017 passed by the Special Judge Prevention of Corruption Act, Court number 2, ADJ, Lucknow, by means of the instant second appeal on the questions of law as enumerated herein above. First, Dr. L.P. Mishra, learned counsel for the appellants, has primarily focused his submissions on the following points. The lower appellate court has committed a grave error in taking the date of valuation of the property in question as the date on which the respondents made his offer to purchase the share of the appellants in terms of Section 4 of the Partition Act. According to Dr. Mishra, the date on which the preliminary decree was passed out to have been taken as the date of valuation of the property. The other issue raised by Dr. Mishra is that the offer to purchase as made by the respondent was not unconditional. It has been urged that though in the pleadings it was stated by the respondents that he was ready to purchase the share, the stranger purchasers on the market value or such value to be determined by the court, but during the course of the trial, from his statement in the cross-examination, he believed his pleadings and had made statement which categorically established that the offer was unconditional, and this could not have been treated as substantial compliance of Section 4 of the Partition Act to enable the respondents to purchase the share of the appellant's stranger purchasers. It was urged that the lower appellate court failed to note that the respondent himself was responsible for delaying in the proceedings. Inasmuch as large number of adjournments were sought by respondent and thereafter it is not justified for the respondent to urge that the date on which he made his offer to purchase the share of the appellants should be taken to be the date of valuation of the share of the stranger purchaser. Rather, in the aforesaid circumstances, the date for valuing the share could not be prior to the date of passing of the preliminary decree, that is, the date on which the contentions issues raised by the parties were resolved and decided by the trial court. Hence, the right of the party to enforce his right under Section 4 would accrue for the first time once the decree was passed and not prior therein. The learned counsel for the appellants has also submitted that the lower appellate court, while decreeing the counterclaim of the respondent and holding that the respondent was entitled to purchase the share of the stranger purchasers at rupees 9 lakh, has erred in exercise of jurisdiction inasmuch as the legislative intent as reflected in Section 4 of the Partition Act requires the court to determine the value of the share, whereas no such determination was undertaken either by the trial court or the lower appellate court. Thus, holding the figure of rupees 9 lakh as the value was not only contrary to the provision of the Act but was also without any basis. Hence, the manner in which the lower appellate court has arrived at the finding is perverse. It is also urged by the learned counsel for the appellant that the respondent was not entitled to exercise his right in terms of Section 4, inasmuch as the evidence on record indicated that the house in question was not a family dwelling house unless and until it was established that the house in question was a family dwelling house. Till then, it was not open for the respondent to exercise the rights in terms of Section 4 of the Partition Act, nor the court was justified in decreeing the counterclaim in favor of the